Yeah. So, good morning, everyone, and welcome to yet another session of Saturday morning sessions, SMS, or we can also say Saturday morning satsang. And now, today, we are continuing with part three of the armor security judgment. And we are grateful to Annapurna ma'am for not only putting her efforts into the presentation, but also for giving her time for 3 consecutive Saturdays. We really acknowledge this kind of volunteering for the benefit of all the faculty group members. So with this, I'll quickly go to Arpit ji. Arpit ji, quick opening remark in 1 minute, maybe if possible by you.
Thank you, Rupji. And although I was not there last time, but I made a point to be present today because I could not miss the discussion led by Annapurna ma'am on armor security. And it's a Herculean task which has been taken by her, and the case studies which have been framed by her are very interesting case studies and the case studies which we would be facing on a day-to-day basis. So it would be an interesting session ahead, and hopefully we would be able to conclude, but it seems more like that it might extend to next session. But a very interesting three sessions, because I heard the second session on a video recording, so therefore, so handing over session to Annapurna ma'am for taking us through the case studies designed by her.
Thank you so much, sir. Thank you for your guidance, Arpit sir. Special thanks to you and to all the mentors and members here. With this session, even I was learning, and I feel still there is a lot of things to learn in this case study. But I was just trying to get into the flow of the case study with the last two sessions, trying to bring out the facts of the case, trying to bring out the circulars, decisions which they have relied to conclude. And I think this is only the decision where I was finding that they have also given the guideline along with the conclusion on that analyzing. So I think I have brought that aspect also. What are the guidelines the proper officer should follow? I think this will also help us to analyze the case studies. And these are the conclusions where they have analyzed in this decision. I'll take 2 minutes to run through this conclusion and then we'll go to the case study. So the conclusion state that Section 6(2)(b) bars initiation of any proceedings on the same subject matter. Audit of accounts and detailed scrutiny of account must be initiated by the tax administration to whom the taxpayer is assigned. Intelligence-based enforcement action can be initiated by central or state tax administration. Parallel proceedings should not be initiated by other tax administration when one of the tax administration has already initiated the intelligence-based enforcement action. Action for gathering inquiry or gathering of evidence or informations will not constitute proceedings. Initiation of proceedings by way of show cause notice and does not encompass summons or conduct of any search or seizure. Expression, the subject matter, refers to any tax liability, deficiency, or obligation arising from the particular contraventions which department seeks to recover or assess. When two proceedings are initiated, the bar of Section 6(2)(b) would be immediately attracted. When the proceeding concerns distinct infraction, the same would not constitute the same subject matter. Two full tests should be there to determine whether the subject matter is same if the authority has already proceeded on same offense, and secondly, the demand should be identical. So these are the certain gist of the conclusions which is there in the decision. And I'll not explain as such because we'll just run through the case studies and we'll try to connect with these conclusions and guidelines, whatever has been given. And the guidelines which have been stated that where commencement by one authority of an inquiry or investigation and is initiated by other authority, the taxpayer has to comply with the summons and mere issue of summons will not suffice. The assessor shall inform in writing the authority that that has initiated the subsequent inquiry or investigation. Department time, efforts, and resources should be borne in mind that action initiated by one authority ensures a benefit. If the investigations of different authorities pertains to different subject matter, then it shall be intimated to a taxable person. Any show cause notice issued in respect of issue which is already covered will be quashed. Both authorities shall decide inter se which of them shall continue with the inquiry or investigation. The taxable person, except statutory protection of duplication, proceeding has no locus to claim which authority should proceed with the inquiry or investigation in a particular manner. The authority first initiated the inquiry or investigation is empowered to carry its logical conclusions If the authorities are not following the guidelines, then the taxpayer can file writ to the High Court. Taxable person should ensure complete cooperation with the authorities and should represent in response to the summons, advancing the objective of harmony and cooperative federalism. So these are the certain guidelines which has been given in the decision. And just to go into those, 1 minute I'll take before going into those case laws. So here in this decisions, we have seen that they have relied on Kupan Kondar, Siddhi Vinayak, GK Trading, Saitla Devi. Only these are the two decisions which are not discussed as such. My limited reading, what I was able to analyze. TVL Vardhan Infrastructure, which is pending before the Supreme Court as on date. And we are awaiting for the judgment of that. And Pinnacle decision is there of Kerala High Court, which has not been discussed in this case, where they have said notification is not required as it is by operation of law, whereas TVL Vardhan Infrastructure decision has stated that notification is required. So I think as on date, notification is not issued. So based on this decision is before Supreme Court. So subject to this, we are discussing on this Armour case studies. And whatever the case studies we are trying to bring out here, just to, because these are day-to-day, we are able to look into those various departments, summons, notices, and adjudication. So we are just trying to frame few of the case studies, and I would like members to add their views on this aspect. So first, the simple case study was someone was issued by the State Department on 10th March 2025. And one more summon was issued by the State Department itself on 10th August 2025, asking the same kind of informations, like only the information requirement was same. Here in first case, we were trying to take the extension of time and we produce only few information here. So we were able to see that one more State Department has issued the notice on summons on 10th August 2025. And then central government also issued the summons on 25th September 2025. More or less the same requirement. They generally have that copy paste of that information requirement. So we were able to see that it was the information which was asked is also more or less same. So now the issue is there is intra summons from two division, and there is one central government has issued the summons. Now we have to analyze whether we can rely on this section 6(2)(b) here, because we all have read on 6(2)(b). So whether we can rely and we can try to reply to the summons issued by the State Department on 10/8, saying that already the summons has been issued by the State Department on 10th March, so you cannot issue the summons. And can you also reply to the central government also saying that already the first summon is issued by the state government and on 10th March, and we are producing the information and it is still on the inquiry stage. Nothing has been proceeded further on that. So we request you to drop the proceedings. So the issue here is, can we, based on 6(2)(b), can we reply to the State Department which has issued on 10th August? And we can we also rely to central government saying that it is the same subject matter or same proceedings? So I would like to have the views from the members on this aspect.
Ma'am, I think as per this decision of Armour, the summons are not the proceedings. And therefore, there can be a multiple summons from the state or central. And as per decisions, this 6(2)(b) is not triggered, what I understand from this decision, so far as this case study is concerned.
Okay, so you meant to say that 6(2)(b) is applicable?
Not applicable.
Not applicable. Okay, sir. Anybody else? Do we have different approach for intra-department and different approach for inter-department? Or can we apply the same approach to both the departments?
What is the difference intra-department and inter-department?
Inter-department is like from the same departments, like same state government.
Okay, like enforcement and
intelligence or enforcement and any other authority.
Vigilance and enforcement together.
Yes, it's possible. So this has happened practically actually. So that's why I've just tried to put it here. So just trying to analyze on this aspect. So we have just tried to discuss on that. I think we can also discuss if any. So what we are trying to look into that, inquiry is not synonymous to proceedings. That has been already been discussed in the judgment also. And proceedings, if we read, it has to start from the adjudication, that is by way of issuance of show cause notice. And here it is only in summons and it is not by way of notice. So as Virendra sir was also saying, we cannot rely on 6(2)(b). And basically, we have to understand that we can rely on this parallel proceeding aspect only in the case of audit or some investigation or scrutiny, but it may not be applicable for summons if the subject matter is same. And this GK trading decision is also discussed in this decision, where they have said that inquiry is not synonymous to proceedings. So issue is, if two inquiry falls within this meaning of 6(2)(b) due to show cause decision as inquiry is not proceedings, we have already discussed it is not applicable. So more or less, we are trying to differentiate between the proceedings, inquiry, and based on that, there is also a guideline saying that the authority first initiated the inquiry on investigation is empowered to carry its logical conclusions. So can we rely on these guidelines, and can we try to reply to the government respective saying that already it has been initiated and they have not yet concluded. So we request you to stay the matter, or just wait for the logical conclusion from the respective authority. So this is also one of the question which we have to look into, that can we follow these guidelines, because this guideline is very clear. The authority first initiated, though. So in this case, it is initiated by State Department. So we can rely on this guideline, and can we try to reply that still logical conclusion is not done. So they can keep the matter. But we have to, yes, sir. Yes, Arpit, sir.
In this case, I would also suggest that whenever we are faced with this situation,
Yes, sir.
so we can have this. Yes, you can share. We
Yes,
can
yes,
intimate both the authorities, because armor security decision itself says that you can intimate both the authorities, and then they have to decide that who has to carry forward. And if they both carry forward or they do not decide, then we have got an option to get the decision and file a writ petition or take it forward that only one authority should decide if the matter is same.
Okay, sir. So I put your views also, sir, here. So you are trying to say that we can try to reply based on this guideline which has been given in the armor decision, and try to say
Yes,
that.
because it is part of the conclusion in para number 97.
Yes, yes.
So it covers both summons and show cause notice. So if we have received summon, and if we go through the guidelines which have been issued for issuing the summons, then
Yes.
it clearly says that the subject matter of the summon and the proceeding should be clearly laid down by with the guideline which have issued by CBIC for
Yes.
issuance of summon. The
Yes.
summons cannot be mainly for conducting inquiry. They have to provide specific the subject matter. And if the subject matter is not there, then we should file a letter that what is the clear subject matter. They need to inform us. And if both the subject matters are same, if we feel that, then we can write to both the authorities. And once they decide, then one can take it forward. If they do not decide and both carry forward and they do not reply, then we can always ask that dispose of the preliminary objections. And if the preliminary objections are decided and we get the reply from both, then we can file a writ petition also. And this in my opinion, this is applicable both for inter and intra-departmental, because whatever the case may be, inter-departmental is a much smaller thing than intra-departmental. Because in case intra-departmental inquiry, officers are bound to know that what is the same department is doing. So this can be an alternative approach when we are faced with the issue of summons on same subject matter. And armor security lays down a guidelines to how to handle these matters.
Okay. So we can rely on, and we can try reply for both intra as well as for interstate proceedings also.
But the ground reality is, whenever summons are issued, it's in the nature of roving inquiry. They just say, bring your books of accounts and come to me. There is nothing else that is mentioned. So in that case, what do we do?
See,
So,
there are
ma'am,
the,
yeah.
tell us. Yes, sir, tell her.
Yeah, so ma'am, so actually all the courts, if you see the courts, they have been consistently holding that did you try to know why the summon is being issued? Have you submitted a letter requesting for the reason? Because at the maybe higher level, at the court level, maybe we are raising this ground that in the summons they have invited, it's a roving inquiry, it's a fishing inquiry. They have not asked me what the summon is for. They're saying that there's some secret information, confidential information. So have you sought to understand what is that secret or confidential information against you, because of which the summon or the investigation inspection is happening? So that's why it is a burden on us, the taxpayers, that we submit some kind of communication with the department, whether it's an inspection wherein we have a doubt. Because in inspection, they're coming with the reason that there is a huge mismatch between your 1 and 3B. And suddenly they come and say you have not reversed your common credit. So whether this is possible, not possible, so that is different ground. But have you actually asked as to why they have come? What is the reason for the inspection? So that's why whenever in case of summons also, no, it is suggested that we as tax practitioners, we should always give a letter to the department seeking the reason for the same, so that this can be agitated in the higher forums. Arvind ji, yeah.
Arupji, just to take your view forward, because there is one recent, although a bit different from the topic, but continuing what you have said, that why we have to file a reply and what is the importance of even a letter being forwarded on any issue by us. Recently, Honorable Rajasthan High Court has decided, in case, if you all remember, there was a circular in case of refunds, wherein the formula in Rule 89(5) had changed to include partial services also in July 2022. So what assessee did that in January 2023, he sent a manual application through email with all the annexures and stating that since your portal does not allow me to file the application, therefore I am filing this application by email and consider this as an application for refund and give me my refund. The authorities did not decided for 2 years. Then he filed a writ petition before the Honorable Rajasthan High Court. Sir, I had filed a manual application since the portal was not allowing me the correct amount which was I was eligible, and the officer has not decided. So the Honorable High Court took the cognizance of the manual application being filed through email, and even not only directed the authority to give the process the refund, but also directed that the operation of the formula would be retrospective, not only limited to the applications of previous period. So in my opinion, whatever communication which we are doing, it has to be, if it is always on record, then we should go for it.
Yes.
Okay, sir. Shall I proceed, sir? Next,
Yes, ma'am.
some case study. Now, the next case study is on ABC companies assigned to central government by way of administration. That is, but state government has issued the scrutiny notice or under audit or ASFD 10. They have issued the respective notice, and taxpayer did not question on jurisdiction and provided all the details. Say, for example, for this audit or ASMT, we can say ASMT 10, they have asked the information and he did not question on jurisdiction that I am assigned to central government, how the state government has issued this notice. So he has not questioned on jurisdiction. Just he provided all the details which was required against this ASMT 10 in ASFT level. And accordingly, the department has issued the show cause notice under 73. He never questioned on this jurisdiction either in his reply nor even in the show cause notice reply also. So the order was passed. The state government has passed the order in original. Now, can the taxpayer challenge the jurisdiction at the appellate level? Because now, if you are relying on this armor decisions, can we question at the appellate level? Though we have not questioned at the initial level of our at the time of replying to this scrutiny, that is ASMT 10, or at the time of adjudication proceedings. So the issue here we are trying to bring out is, can we question on the jurisdiction at the appellate level, even though we have not replied in our show cause notice or at the initial level? So the question here is, can we challenge? Can we bring out this additional submission saying that we were assigned to central government, but state government has issued this notice? So can we question on jurisdiction? I would like members to add your views.
Ma'am, in my view, since it's a point of law, which is an error in jurisdiction, so this can be taken in the higher forum also if I have not taken it at the adjudicating authority level. Though appellate authorities are averse to this because they often even are writing now that you have not taken this ground at the adjudication level. But point of law, in my view, we can take it at any stage.
Okay. Anybody else?
View of other members.
Yeah.
Any other member? Any other view? Contrary view?
Arupji, there is this case of Juhi Industries, which
Yes.
said that if you have not taken at the initial stage, you can take it at a later stage also. You can object it at a later stage also. So support
Yes.
from that is not only at the initial stage, any subsequent stage also you can object it.
Right.
Yeah, one more test we have to do here is one thing is we agree that it can be challenged at any level, though it is not challenged at initial level, does not mean still officer is obligated to comply with. One more test we have to see, especially after armor, is whether the scrutiny notice or audit or ASMT 10 is based on enforcement-based intelligent action. That we have to just check it. If those are issued by way of enforcement-based intelligent action, then we cannot question on jurisdiction because state jurisdiction has right to issue even though the ABC is assigned to a central jurisdiction. This is what this also testing has to be done. We just cannot directly question on the jurisdiction. We have to also see why they have been issued. Is it by way of any enforcement-based intelligent action? And if it is not intelligent-based enforcement action, then you can question this before the respective authority. But simultaneously, we also have to look into those decisions which are still pending before the court. I think Ram agencies have not gone to the Supreme Court, but Vardhaman has gone to the Supreme Court, where they have tried to question on the jurisdiction, saying that if you're assigned to the state jurisdiction, then only state jurisdiction can issue the notice or can conduct the audit. So that is what I think we have to look into this aspect when we are going to reply on the jurisdiction. So these are the things. And I was just discussing with Arpit sir also. One more point he was trying to bring out is, say for example, at the initial level, we are not questioning the monetary limit because as you all are aware, there is a monetary limit which has been specified under the respective circular. That is, I think 3/17, where they have specified there is a monetary limit for each of the officer to issue the notice or to conduct the audit. So in that case, if they have not complied with that monetary limit and we have not questioned at the initial level, still it can be questioned at the appellate level also. So similarly, when we think on monetary limit also, I think even on this jurisdiction level also, we can question at the appellate level. So in all our cases, wherever we would have missed to argue on this, jurisdiction, we can take this argument at the higher authority also, before the higher authority. And then,
Annapurna ma'am,
yeah.
but for a monetary limit, there has been a judgment of PAVA, I guess,
Yeah.
which held it is just a procedural matter. Even if the superintendent has issued for a higher authority, it is just a procedural thing. And still, the show cause notice cannot be said to be invalid. It should be stated to be valid only. In excise regime, the judgment is there.
Yeah, but here now the circular has given a clear guideline also, and recently they have issued for even penalty and 74, where they have given a specific monetary limit for a respective jurisdiction. Say, for example, if the superintendent has issued a notice for 1 crore, we have already replied, already the order has been passed. Later on, while doing an appeal, we were able to find that already they have crossed the monetary limit. We have not questioned on that jurisdiction. I think at the appellate level, we can still question on the jurisdiction because they are supposed to comply by the law. So so according to our discussion, what we have analyzed it, even it can be because Arup sir was also saying that if it is a matter of law, it can be questioned at the this appellate level also. So I think even that monetary limit also we can question at the appellate level because there is a specific instruction guidelines which has been given for, though it may not be, it is not there in some of the states, it has not been given for the state department, but they have specifically issued for the central department. So in that case, I think we can question on monetary limit.
Madam Venugopal,
Yes, sir.
to interrupt. Question to you and Deepak both. On what grounds you are saying 160 subsection 2 will not be invoked, where we are questioning the jurisdiction, questioning the notice at a later stage?
No, I agree that they have the power to rectify their errors. That is fine. But the issue is they have to come out, like now recently we have seen for this consolidation of multiple show cause notice where they have tried to rely on 160 subsection 1 and 2 of that act, where they can rectify that procedure and accordingly they can issue that notice. So similarly here also they have been, but until we don't question it, tomorrow the appellate authority also can look into that officer has crossed their jurisdiction and accordingly they can consider this submission is what my view on this.
Agreed, madam. But
Ma'am,
how the question after audit is concluded, everything investigation is concluded, and they are now passing an order. Is this the time to question, or should we only question at the first stage? I think still the 160 subsection 2 will hold. If I am not questioning and I am proceeding with the entire adjudication process investigation process, everything. And at the time of order, I am saying, no, no, you do not have an authority, so this order is null and void. I still doubt that is possible.
Ma'am, can I add?
Yes,
Yes.
yes.
Yes, sir. Sir, Venuji, and ma'am, in my opinion, see, there are two things. If we go first, we go by section 160 subsection 2. If I can share the screen of the section.
Yeah,
Let me-
you can, yes.
Yes, sir. So this is the section, and if we go through 160 subsection 2, then it says the service of any notice, order, or communication shall not be called in question if the notice or order or communication, as the case may be, has already been acted upon by whom it is issued or where service has not been called in question, or in earlier proceeding commenced, continued, or finalized pursuant to such order. So 160 subsection 2 is only applicable wherein the service is in question, not the jurisdiction. So, in my opinion, when we are challenging the jurisdiction, 160 subsection 2 is not at all applicable, because here we are only challenging the service part. Now, coming to the jurisdiction part, that whether it can be challenged at any stage, let's take an example. See, the absence of jurisdiction is now called absence of jurisdictional fact. Now, take an example that I am living in my home, and tomorrow I decide that the neighboring house, any person in the neighboring house shall not enter between prior to 10 a.m. and after 6 p.m. And supposedly the owner acts upon it. That does not mean that I have got the power to decide who comes and who does not come into his house. Tomorrow he can say, who has given you the authority to decide that who will come and when will someone come into my office. So absence of jurisdictional fact is something which can never be granted even by Supreme Court. So if an authority has acted beyond his jurisdiction, even the Supreme Court in their decisions, various decisions have had that if there's an absence of jurisdictional fact, even the apex court cannot give the jurisdiction to that person, and there is a logic assigned to it. Supposedly, take an example that tomorrow a show cause notice of 100 crore is issued, and that is issued by superintendent. Now, even if I have appeared, that does not become an estoppel on me that I cannot challenge, because he does not have that power and no one can grant that power. So in my opinion, the absence of jurisdictional fact can be challenged at any point of time, and and how the judiciary has evolved over the period in GST regime. In case of Section 74, Jatin had also shared the recent decision of Supreme Court when he had got a stay, and there are many other decisions of High Courts also, wherein they had said that if intent to evade is not proved while invoking Section 74, this is also an absence of jurisdictional fact. So merely if I have not challenged Section 74 at the point of, say, before the jurisdiction office, it does not give them power to invoke, because invoking of the power has certain conditions attached to it. That conditions have to be satisfied by the officer, even though I have not challenged. So therefore, I would say that it is not an error in law. It is something which I do not have, and merely because someone has not challenged it, I cannot be got that power. Because if that view is taken, then by virtue of Section 2, subsection 2, clause 91 and Section 5, only the commissioner has the power to assign functions to various authorities. But if we take the thing that if the assessee is not challenged, the superintendent will get the power of additional commissioner. Then in Section 2, clause 91, Section 5, we have also to add that either by the commissioner or by the assessee who is not challenged, the officer would get the power, and that is not a case. So only the authority who can assign the power is commissioner, and the commissioner is not assigned that power. Merely because the assessee is not challenged, the officer would not get the power.
I completely agree with Arpit-ji. And actually, there is this, like as Arpit has rightly shared, there are two things. One is error in jurisdiction, and another is the absence of jurisdiction. So both of these things can be argued at a higher forum. The reason is, I was reading one of the recent, I don't remember exactly. The reason is that if this jurisdiction is in error or absent, then the entire dispute resolution mechanism falls. Because whenever this jurisdiction has been set up, whether it's a monetary jurisdiction, geographical jurisdiction, even there was a recent service tax matter wherein geographical jurisdiction was set inside. that if a person who is having a jurisdiction over, say, a place called Esplanade, can he pass an order for a place which is Salt Lake, which is not within his jurisdiction? So if these things were not there within the realm of the law, then the person would be remediless and anybody could go to any extent. So that's why I think, even as Arpit has rightly shared, this ground is a very strong ground wherein we are taking these grounds of error in jurisdiction or absence of jurisdiction, which we can also take in the higher forum, because otherwise I'll be remediless. Even if somebody does an act which is not permissible by the law, just because he's done it and because of my eagerness to be compliant with the law, I've submitted a reply, then I cannot say that, I've accepted that legal position and I'll not fight in it against it in the higher forum. So over to you, Annapurna ma'am.
Yeah.
Just a quick
Or
question,
here
ma'am.
the views. Yes. Yeah.
For the 3/17 is applicable only for central administered registrations, but for state registrations we are not able to enforce. I mean, there is no such circular, right? I mean, is it across India that way?
Few states are having.
No, yeah, in West Bengal we have, ma'am.
Yeah.
Also in Kerala, we have pecuniary jurisdiction.
Yeah, it is there in
We have.
Karnataka. We are not having.
There in every state, ma'am. Or Rajasthan, we also have.
Yeah, few states are not having, sir. Otherwise, most of the states are having. So here I've seen like CTO was issuing 5 crore order also. So here I'm not seen as such in Karnataka, but few states are having as such.
May I, ma'am, please?
Yes, sir,
And
please.
for
Yes,
all the
Bhavik, sir.
participants, ma'am, can we go back to that slide which we were discussing? What I need to draw attention of all the participants to the point and their personal experiences, if they have, regarding this. The point is about that if audit or scrutiny is undertaken based on the enforcement-based intelligence actions, normally, to my knowledge, it's not happening that enforcement-based intelligence actions, they are not initiating any scrutiny or audit. But this emanates from this line, I believe, emanates from the para 51 of this Armour judgment.
Yes.
Just I want to know from the all other members, have anyone experienced such cases that the investigation sections, etc., they have started, they have issued an ASMT 10 or they've initiated, they've requested to initiate any audit proceedings. Are there any such instances?
Gurjit sir, it is
vice
not
versa.
intelligence based, but back in 2018 and 19, before the mega judgment case, state GST issued ASMT 10 for central GST for interest on gross tax.
Yes,
in Kerala.
Yes, sir. Such instances were there, but they are not valid in a way that that cannot be done. The cross empowerment is only for intelligence-based enforcement actions, and all of us just understood that it will be just starting from an SCN and going ahead to adjudication. This para 51 of Armour judgment has, while it has clearly said that scrutiny and audit has to be taken by the respective administration under which the taxpayer is, but para 51 just in a manner adds a caveat that we are not prohibiting that if scrutiny or audit is done based on intelligence based of enforcement actions, then cross empowerment can be there. So have there been any practical incidents like that? That is, I would like to draw everyone's attention, or maybe based on this, if the authorities have also eagerly read through this judgment, we may see going further such instances happening, because earlier they were not happening, or were they happening earlier? So just an attention of all the members. It is an important aspect which para 51 says there.
Yes, sir.
No, though it is not issued in the name of audit and ASMT, they are in the nature of those kind of this only. They say that one is not matching with 3B based on intelligence based assignment received. The issue that are raised is 1 versus 3B, 2A versus 3B, common reversal of input tax credit.
Yes.
So do they have the
Gurjit sir, I
jurisdiction?
have a question for you.
Yes, sir.
You said that the intelligence department, the department, if they are keenly reading through para 51, might get to expand their net. But from what I've understood, in Kerala, the state as well as in center, audit parameters are set by the centralized
team, whoever is there, and they will set out the parameters and select the audit and assign to the respective audit commissioners. So when the data parameters are being set at the central level, they are only taking the data from their own jurisdiction taxpayers. So unless something happens at the top, I don't think the respective audit commissioners will independently go ahead and expand their audit selection criteria.
Yeah, that is the normal practice. You're very right. One is going further than one thing is that there is section 65 which says for audit that the commissioner has to decide. That is what commissioner may direct in the audit of any person. Besides this, the practice like which you are referring to, there is always a scope for that any taxpayer can be individually also identified for audit. That scope is there in all the administrations, even in center-based administrations. The bulk of their audits would be identified in this manner only, which you have just stated. But there is always, in the manuals also, they will say that if there is something, even the lower, say, in the hierarchy, the lower jurisdictions, they can push the information upward to the commissioner, sharing the information that this taxpayer may be audited because of this reasons, and then the commissioner may direct. Act also allows that, and practically also in the manuals also, that little part is there. But like Ashwani sir is writing that in the guise of 67, they are asking about doing scrutiny. But GSTR 1 and 3B gap is it an intelligence-based action? So if it happens, can we argue on the basis that this comparison of these two returns is not an intelligence-based information, though the underlying fact may be there that this query has arisen because of some intelligence-based action. So we have to be a little aware of these things and be cautious or be prepared exactly for these things if they start happening. How to handle that, how to respond to all these if they start happening.
Yes, sir. So I think we'll continue, sir.
Yes, sure, sir.
Yeah,
If
yeah,
anyone has
yeah.
to share anything on this,
Yes,
any views.
just
No,
to add,
as you have rightly
I'm-
concluded, sir, this is actually happening. As I was just sharing that, if you are using credit too much and you are not paying in cash, that's a reason of intelligence. If you are not using credit for 4 months, okay, and a credit of 2 crores odd is lying in your electronic credit ledger for 4 months, because of that also section 67 is being executed and there is an inspection. That's an intelligence-based action. And when we ask what is intelligence, I have an ITC. I'm not utilizing it because I'm not supplying goods. That's it, simple. I had to buy the goods. I bought it, and then there was some industry issue. I could not sell the goods. So all these things are coming up, and yes, we are challenging that in that stage itself, saying that how is this intelligence based and where is the bar in having an electronic credit ledger balance for 4 months, or where is the bar in all these 1 and 3B differences when Circular 26 of 2017 clearly says that there could be an error between 1 and 3B, and you can rectify it in subsequent returns.
Sir, is
If it's an error, how can you
Sir, is
distinguish
it happening? Are they using cross empowerment for these things like this? Say, is the center
Yes,
initiating for state
yes.
or the state based? Oh,
Yeah,
array.
yes, exactly.
Yeah, that is what I wanted the
Yeah, they're using
discussion to be on
cross-empowerment
this
for this.
basis.
They're using cross-empowerment for this. They're saying when we tell, I'll not say about which authority, but when the one authority came, we said, sir, but we are within the administrative jurisdiction of the other authority, and they are getting to review this. Why should you come into the picture? There is a provision wherein they can check. And where is the intelligence basically? It's having an electronic credit ledger balance for 4 months. Where is the intelligence? I'm not using it. That's it. So then they come into the question, no, what it is, this clandestine removal is there. You already removed the goods and
Arup,
show me
sir,
your stock.
one doubt.
Yes, sir.
Hello.
Yes, sir.
Okay. Just keeping aside intelligence for the time being, I'll first take 267.2 and reason to believe. So in many of the judgments, I've come across that the court said that court cannot substitute its wisdom on what is the sufficiency and the character of the reason that the JC has formed. It cannot substitute as long as there is some. So in similar fashion, even if we say this is not intelligence, as long as the proper officer said this is sufficient intelligence, can a court substitute its wisdom of what is a measure of intelligence that is required to qualify as intelligence-based information action?
No, it cannot. But again, we are linking it with the bar. Where is the bar in the law? Like where does it say that 1 and 3B mismatch cannot happen? Cannot not be an error. Why are we taking it that in a one single 1 and 3B mismatch is due to suppression of turnover and all those things? Or in this matter, which I'm arguing recently on this electronic trade ledger matter. So we have asked the court, the honorable court, that where is the bar in the law to maintain my ITC? Which section bars me? What is the violation that I have done because of which they have a reason to believe that yes, there is a suppression or there is a clandestine removal. So it's based on based on best guess basis that since this person is having electronic trade ledger balance, it may be so that he's selling it in cash. So that's where we are trying to fight out that as Gurjit sir has shared, that intelligence based, it can be intelligence based, and we are not questioning the wisdom of the approving authority, whoever has approved the INS 01. We are not questioning his wisdom. But what we are questioning is that where is there a bar in the law or where the law states that you cannot do it. Say this 1 and 3B mismatches, and yes, for other things, maybe the other issues like fake credit issues, there is a statement against somebody, there is a finding against somebody that goods have not moved. Even now, this recent thing about FASTag information they are getting that goods have not moved, goods have moved in the other directions. Those are still valid, though we can substantiate why it has to move to a different things. But where it is not possible to substantiate, I think there we should fight it out and take the grounds.
And Arpit sir, I'd like your views or any other members' views specifically on the part that in Armor judgment, in their concluding paragraphs at the end of the judgment, 97 or the other paragraphs, they are clearly laying out that scrutiny and audit proceedings have to be carried out by the respective jurisdictions under which the respective administrations under which the taxpayer belongs. So considering this concluding paragraphs and a mention in the paragraph 51, what is the significance of para 51 vis-a-vis the conclusions there? How much weight does it carry? What is the significance which can be assigned to this? It is just like, I mean, we do not say that this cannot be done, but what they are concluding is that this is to be done. So what is the significance of this particular statement vis-a-vis the conclusions they have mentioned at the end of the judgment?
Hello. Hello.
Yes, Boli.
Yes, sir. You are
Ruji, I'm just sharing para 47 and 48 of the Armor Security Judgment. And then, Gurjit sir, I would try to share my views on the query raised by you. See, para 47 says the concept of cross-sub has been retained within GST framework in order to maintain robust enforcement mechanism and prevent any scope of evasion of taxes. For central and state administration have been armed with the power to initiate intelligence-based enforcement action. And that is an action that is predicated on information of tax evasion emanating from the value chain of transaction rather than from any administrative scrutiny by way of audit or accounts or returns. So there are two important things which are coming from para number 47. That first, for an intelligence-based enforcement action, there has to be a predicated on information of tax evasion. And that is from value chain or chain of transaction, not from any database which is there for 3B1 or 3B2A. Now, para 48 further explains that what is the scope of the information. Such gathering of intended to be a non-intrusive exercise. The department relies on data analytics, validation with third-party data, or other methods to collect actionable intelligence via analytical tools, human intelligence, modus operandi alerts, as well as information through past detections. That means when we read through these two paragraphs, there has to be an evasion in the value chain based on the intelligence or human intelligence or modus operandi alerts. Last is the very important line. Taxpayers must be mindful that intelligence about invasion of tax cannot be procured from them through issuance of summons or other non-descript letters and corresponding. So first, for initiating a cross-empowerment, there has to be an information which is on record, not being sought from the taxpayer. And secondly, it has to be for an evasion of tax. So in my opinion, if a 3B1 or 3B2A or something which you have said that non-utilization of ITC is the basic reason, then on the basis of para number 47 and 48, we can always argue. And why 51 has said that audit of accounts or scrutiny can also be done in case of a cross empowerment, because they said once intelligence based information is there which is leading to a tax evasion in value chain, then the other jurisdiction is empowered to carry out and execute the information by whatever way possible, either by way of 61 or by way of 67 or by way of 65. So what they have said that intelligence based information has to be there, which predicates evasion. Once it is there, then there is no bar on the jurisdiction that how they want to execute. Because if they would not have said this, then the only proceeding would have been section 67. So if there is an intelligence based enforcement information, say for 1 lakh rupees, and they are not allowed to carry out a scrutiny for that 1 lakh. So that does not mean that they would, if para 51 would not have been there, then for that 1 lakh also they would have to initiate a proceeding under section 67. So that is my opinion, because this judgment has very clearly laid down what is the prerequisite. And once the prerequisite is satisfied, then anything by any manner and by any proceeding can be done. And lastly, to the part of conclusion that in para 96, they have not mentioned what they have mentioned in 51. In my opinion, what they have done in 96 and 97, they have only tried to summarize. They've only tried to summarize, and on the basis of that summary, they have included most of the matters which are there in the judgment. But if some of the matters have not been included in the judgment but have been explained in detail, so in my opinion, they would still prevail and they would still carry the force of the law. This is my understanding.
Sir, but
Okay, so thank
practically
you.
all the return data will be with the administration only, no, sir. The other person will not have the visibility of what has
No,
been
ma'am.
submitted.
No, ma'am. Both the jurisdictions have equal access to the data, and that any one of them can see. But that is how they have put a restriction. And in my opinion, whatever proceedings would have happened up till now, post Armour, there would be a completely different landscape that how the proceedings are being conducted. Because in one of our cases, practically what has happened recently, that a survey under section 67 was completed and a detailed report was issued by state GST. The assessee is falling under central GST. They have issued a notice notice for audit under section 65. Basis upon the conclusion of the Armour in para 97, wherein they have said, as we have discussed in query 1 also, that the taxpayer is required to inform, then the person who is carrying out the audit is required to communicate with the state officer, and then he has to dispose of the preliminary objections. We have filed a letter to the audit authority who is conducting audit under 65, and we have asked them to mandatorily communicate with the other officer in state, and whatever communication they have received, we have asked them to provide us and allow us to make our submission on the answer being received, and then give us an opportunity of being heard, and then dispose of the preliminary objections, and then only carry out the audit. So this is upon us that how now we use this Armour security judgment in various proceedings which are being carried out by the department. So whatever has happened prior to this cannot be a benchmark that going forward this that would continue in the same manner.
Yes. This has actually changed the landscape.
Yeah, that is what I was seeking attention to this significant part of the judgment, a discussion on this. So we can say that if there are actions based regarding audit, scrutiny, etc., by a different administration rather than the administration under which the taxpayer has been assigned, if these actions are related to audit or scrutiny, etc., then our endeavor as a practitioner or a taxpayer should be to first probe whether it is based on the underlying requirements, that the evasion of tax and both the things, not only the evasion of tax, also is it based on an intelligence based action? Do they have intelligence, and does that intelligence indicate evasion? So we should try to probe these aspects at the earliest possible, by way of correspondence, etc., like Arpit sir is saying for there, and then see how it proceeds, it goes further. Would that be the right way?
Yes, sir. Yes, sir. And we have to be, in my opinion, this armor security judgment, each line has its own significance. And every one of us should go through this judgment and each line many a time, because each line will open a new point of argument in case of proceedings. And be mindful of the fact that even if the officer is not accepting and we put that ground, then in subsequent appellate proceedings or before tribunal, this would be the first issue which would be decided, and then only the matter would go on the merits.
Yes, and adding to what Arpit just shared, which we are also sharing in the different seminars for armor security, is that the last line of para 48. So it cannot be as Soumya ma'am was saying, that it's a fishing exercise or a roving inquiry which is happening. So they have come with something, and now you go into the summon, and suddenly they come to know that you are doing some other kind of violation. You have not reversed the ITC for expired medicine. You're a pharmaceutical manufacturer, and they had come to you because you are not issuing the UA bills on time. So that was the reason for the summon. The main reason for the summon was that you are not issuing UA bills even though it's going beyond the threshold limit. So during the summon, they ask you different questions and all. They suddenly come to, okay, since you're a pharma company, so do you do reversal of expired medicine? So we need to be careful where the line ends. You are calling me for a summon for UA bill infraction, so I'll answer to all those things. Beyond this, for any other thing, maybe you'll have to start with a separate thing. So just because I've come to you for a summon for UA bill and you ask me and get from me facts regarding non-reversal of ITC for expired medicines, that cannot be a reason for the show cause notice. So those places also we have to take an objection. So those are the things that now after armor, I think we also need to keep in mind. I think, ma'am, how many case studies have you completed?
Yes, sir. As we are nearing it's almost 2 minutes or 3 minutes to
Arpit?
10 in.
Yeah.
So, sir,
Good, sir, yeah.
one is this aspect. The other important aspect of this judgment, to my reading, is that on the face of it, it says that proceedings start only after SCN, and before that there is no cross empowerment, etc. But it also lays down in the guidelines that even though 6(2)B does not activate before SCN, etc., but even the summons, etc., if two simultaneous authorities are handling it, they have provided a guideline that you must raise objections and only one of them can carry on investigations. They should decide between them. If they do not agree, they do not come, and then it can be the higher courts can intervene. So that is another significant part, that though they have on the face of it, it says 6(2)B does not get activated before SCN. But they are also providing a guideline that it does not mean that the investigations can be done on the same issue by two simultaneous authorities simultaneously, and taxpayers has to respond to all of them. They have provided a path that please object to it, communicate to them, send letters, and if they only one of them should carry out the investigation, if they do not do so, then this. So that is another significant part.
Yeah, Gurjit sir, here I'd like to share about one important thing here. जो हम लोग पहले नहीं करते थे, but we started in fact after GK trading of Allahabad High Court and I think Coupon Industries of Madras High Court, we started doing that. That is, whenever a proceeding is going on, previously we used to delay the matter, give them replies and all. Sir, क्यों करेंगे SCN? सब तो ठीक ही है. But now we are on the other side. We tell them you issue the SCN. अब कर दो, we'll reply. Why? Once the SCN is issued by one of the authorities, the other authority is set on an embargo on the same subject matter. So at least you are fighting with a lesser evil. So that is the first thing which has also been explained here. And in para 68, they have clearly said that notice is to be issued only under those sections, 73, 74 and all those sections. You cannot just write a letter and say this is a notice. Okay, and that the proceeding has started. So again, that is one important thing that we need to keep in mind, that getting a letter saying that you reverse this particular ITC common credit, it does not mean that it's a notice and because of which the other thing. Having said that, the second aspect which you have raised, that we have only 1 minute. The second aspect that you have raised is that though the parallel they are still valid as per the Armour judgment since the proceedings have not set in place. Also, herein lies the role of the tax practitioner, that whether we are visibly bringing it into the notice of both the authorities. So it's a second authority who's coming. Say state authority has come in first, and say it's a central authority which is coming second. Though we are appearing for the secondary authority for the summons, are we visibly bringing it there that I'm not answering to any summons replies right now? I would like to cooperate only once the proceedings by the first authority is complete. So are we bringing that into picture? Because the second authority is taking into question that nowhere has it said that I cannot do the investigation, I cannot do the inquiry because the SCN has not been issued by the other authority. So that's a very thin line that we need to move cautiously.
Sir, we must pay attention to the notice received a few minutes back from Venugopal, sir. That is a notice which requires immediate attention, that we should close by 10.
Oh, Acha, ma'am, Venuji is saying that we have hijacked ma'am's session. Yes.
No, sir, it was a good discussion and a lot of perspective brought on that.
Maybe we'll need ma'am's session, one more session.
I think before concluding, even is it visible, sir, actually?
Yes.
Yeah. So even this aspect also, I think we'll take it up later, like whether notification is required or not, though it is pending before the Supreme Court, because if the notification is required, then I think few of the aspect on this Armour might also change. So I think this is one more, because there are few school of thoughts where they said that once Armour decision has come, now issuance of notification is not required, and this decision may not hold good. And there are some other school of thoughts where they say that I think if the Vartaman comes with a decision, I think then there is a possibility of different aspect of Armour decision also on some aspect. So I think this is what we have to see in our next session also. So accordingly, we'll discuss on those aspects and some of the points which are raised by sir and Arup sir, Purjit sir and other members. A few of them are discussed in our case studies. In the future case studies, we have already discussed few of the aspects. When we are going to discuss on those case studies, we'll try to discuss in detail with the facts of the case. So because the time limitation is there and it's already 10, so I would like to conclude, and I got late by 5 minutes for the session actually.
No. Not a problem at all. I think that is right. We have 3 minutes left because we started 9. But anyways, I think thank you, Annapurna ma'am. And as Venuji has rightly said, we have hijacked the session. So next session will not hijack the session.
No, sir.
We'll first complete the session, then we'll have it. But I think today's discussion which brought in by Gurjit sir, I think this is also very vital. Some of the aspects, that final aspects that is brought in along with your case studies. So over to Venuji for a vote of thanks.
Yes.
The prediction made by Arpit sir in the beginning of the session that we will require one more session, that has come through. He had already made a prediction.
Yes, he's turned astrologer now.
That's the power of being a lawyer. Okay. All right. So, Annapurna madam, special thanks for igniting this topic. And as usual in our SMS, we will have difference of opinions, different views, different thoughts. But this is a learning. I think this is what we are learning is like Section 6, which is one of the neglected section. And even though we have Armour judgment, we still find that, okay, we have different views in application of it. We will try summing up this session in the coming thing. I don't want to delay our regular readings. The initial thought is, like I said in the last session, that in a month we will pick one week on the case law. But what I'm seeing is when we pick a case law, it is going beyond 2 weeks, 3 weeks. So we will see how we will balance the discuss on the notification circulars, which are key important. And this, but nevertheless, thank you so much, Annapurna madam, for bringing different questions to our mind. Request if you can also share the presentation in the group and your final summary notes.
Yes.
And in the next session, we will club with some other thing. Otherwise, we will keep we are experts in interpreting and dragging. So we will conclude it. And we will continue with a new topic in the sessions to come. With this note, we will conclude the session for the day. Thank you, everyone.
Thank
Good
you,
day.
sir.
Thank you, everyone. Good day.
Just
Thank
to
you.
add,
Ah,
we
ah,
were
ah,
discussing intelligence-based enforcement action, having an
ah.
intelligence-based discussion.
And we are concluding on time. Venuji, we are concluding on time. We
Yes, yes.
started at 9:05, we are concluding on 10:05.
I know.
Correct.
It's like
Fine.
there is a ruling. Just because you came late, you cannot go late. So it will be
Okay.
2 violations. Let us only do 1 violation going forward.
Okay.
Okay.
Bye,
Done.
bye, bye.
Thank
Okay.
you.
Bye, everyone.
Thank you,
Bye.
everyone.
Thank
Thank
you.
you very
Thank
much.
you.
Thank you,
Okay,
ma'am.
Thanks, everyone. Thank you, ma'am.
Thank you.
Arupji, you have to conclude the meeting. End the meeting.
No, I've made you the host actually.
No, you are the host.
अच्छा, I'm the host. ठीक है. Okay, I'm concluding. ठीक है.
Done.